what happened is that the government made an assessment against Belize International Services Limited, who used to operate or manage, I should say, the registries for shipping and IBCs for the government. They assessed the company for over $30 million in taxes going back to 1993. And what the judge has said is that that was an unlawful assessment, and she said so because Section 130 of the International Business Companies Act specifically exempts all IBCs from the payment of taxes, and so she quashed the assessments by the commissioner. Very importantly, what the judge said was that the argument by the government that BISL was carrying on business with persons residents in Belize meant that they were afoul of Section 5 of the Act, which then meant that they were available to be taxed. She says that that is wrong. Even if you carry on business with people resident in Belize, which is not allowed by the law, it doesn't mean that you are no longer an IBC. You continue to be an IBC, but you are subject to a fine. And it is not that it means that you can be assessed.
What does this mean for the concurrent claim in regard to the taking over of the two registries, which I know is in another court?
Well, that is in another court, and that will come up later this month before Madam Justice Arana, where we are seeking constitutional relief and damages for the unlawful taking of our client's property. But that is before Justice Arana. It is helpful to the client because what we were facing, or what the client was facing, was an assessment for $30 million with interest and penalties continuing to accrue on the one hand, and then clearly the government was going to say they will set off whatever damages in the other matter against the $30 million. Well, there is no $30 million.